Day 7 of the plea for marriage equality for LGBTQIA plus persons concluded today. Last week, the bench asked Solicitor General Tushar Mehta to confirm with relevant union ministries to suggest administrative measures to give LGBTQIA plus couples the same benefits granted to married heterosexual couples. In today's hearing, the Solicitor General suggested the creation of a committee headed by a cabinet secretary and invited suggestions on issues to consider from the petitioners. While the petitioners agreed, they stressed that this committee could not substitute the reliefs that they were looking for. They highlighted that marriage is crucial as it gives meaning, identity, and purpose. On one hand, the bench agreed with the petitioners, and CJI Chandrachud said they would deal with the conceptual issue of the right to marry under the Special Marriage Act. The creation of a committee merely keeps options open for the future. However, Justice Bhatt stated that while administrative changes may not be the full extent of the relief sought by the petitioners, this was still a notable step towards securing benefits to LGBTQIA plus persons. Mr. Mehta then began his concluding arguments. According to him, the petitioners wrongly relied on the Shafeen Jahan and Shakti Vahini cases to argue that the right to marry was a fundamental right. Both cases dealt with widely different facts, and neither case dealt with the rights of non-heterosexual couples. The SC was not considering marriage as an abstract in these cases, but in their specific contexts. Attorney General R. Venkatramani followed and repeated many of Mr. Mehta's key arguments. The SMA was only meant to facilitate heterosexual intercaste and interfaith marriages. It did not leave out LGBTQIA plus persons intentionally or by design, and hence it could not be considered discriminatory. He also repeated that the court could not rewrite the Special Marriage Act, as that would breach the separation of powers between the Supreme Court and Parliament. This would violate the basic structure of the Constitution. Finally, Senior Advocate Rakesh Dwivedi argued that replacing the words husband and wife with spouse would offend the dignity of heterosexual couples. Curiously, minutes later, he argued that dignity had no connection with marriage. On multiple occasions, he posed a question: why the rush to recognize marriage equality? He likened it to the gradual struggle for women's rights and pointed out that women still don't have rights under the Agricultural Reforms Act. Quelling concerns that many will be deprived of marriage rights until they are gradually introduced, he stated that all causes take time to succeed and all causes have martyrs. Mr. Dwivedi will continue his arguments next Tuesday. Thanks for tuning in. Visit the SCO website for more.